You, Deanna, friends, colleagues. We are often told that the international community considers it of utmost importance to restore a political horizon towards a two-state solution, securing a just and lasting peace. Regrettably, and despite that recognition, the occupation has become further entrenched with Israel's systematic, forcible alteration of the legal status, character, demographic composition of Palestinian territory. In the backdrop of Dr. Albanese, Francesca's report is the protracted character of Israeli occupation, numerous well-documented breaches of international law, and the humanitarian plight that it necessarily creates. Much of my work focuses on that. It has led scholars, a succession of UN special rapporteurs. I'm very encouraged to see a former special rapporteur, Professor Richard Falk, through Professor Michael Link, and to Francesca, and indeed the Commission of Inquiry, to accurately characterize it as premeditated to permanently settle Jewish Israeli population in occupied Palestinian territory. And as such, we should refer to it as an act of aggression, as any annexation by the use of force of the territory of another state or parts thereof would be considered under international law. In fact, this is the current political bon ton. My careful prediction is that Israel and its emboldened incoming government will become even more heavy-handed in repressing, suppressing Palestinians, introducing changes that we've already seen to the rules of engagement, methods, and means used in administering, prolonging its occupation. Just to give you one example, the use of lethal drones. Until very recently, the preserve of Gaza has now been deployed. These lethal drones have now been deployed to the West Bank, used in extrajudicial execution. We've seen settler harassment and violence targeting Palestinian persons and property. They're prevalent in those areas where Israel established outposts, settlement neighborhoods, owing to the particular demographics of those and the complicity of Israeli armed forces. We've seen spatial plans for settlement establishment and expansion, including those advanced by the outgoing government. They're centered in those areas most disruptive to a territorially contiguous and economically viable future Palestinian state. It's indicative of a continued attempt to acquire the territory and in perpetuity. The incoming government would do more of the same, Corollary to settlement establishment and expansion, we've witnessed a surge in the destruction of Palestinian property throughout 2021 and 2022, including structures provided as humanitarian relief, funded by the EU and its member states, implemented by NRC and many of the IDA members. The Israeli acquisition of parts of the West Bank is matched with the severance of Gaza from it, which would otherwise constitute a single self-determination unit, a single unit. So rather than advancing towards a politically independent, territorially contiguous, permanently sovereign Palestinian state, Israeli policies retrograde over time towards permanent alien rule over the Palestinian people, denying them the realization of self-determination. And given that the denial of Palestinian right to self-determination is intentional by Israel, inherent to its prolonged occupation of Palestinian territory and the disenfranchisement of the Palestinian people, we arrive again at the nadir of confidence in the pacific and just resolution of the Palestine question. So what are we to do as principled global civil society? We have no answer other than the unwavering enforcement of the law of self-determination as the cornerstone of any political solution, not an afterthought. The report presented by the Special Rapporteur contains such appealing observations and recommendations that we would be remiss if we did not engage them collectively and with a sense of urgency. In the time remaining, allow me to focus on three elements in the report. First, the violations described in the report expose the nature of the Israeli occupation. And I quote, that of an intentionally acquisitive, segregationist, and repressive regime. So the first priority for global civil society is the protection of Palestinians whose vulnerability in humanitarian needs increase by the year, by the month. Current activities aimed at ensuring the safety, protection, well-being of the Palestinian population, including the provision of humanitarian relief, monitoring and reporting of international law breaches, and humanitarian diplomacy that comes with it, legal protection through information dissemination, counseling, litigation, international public interest advocacy, they must all continue. They are absolutely necessary, in my view. We should consider establishing a more visible humanitarian presence, not because we are tempted to think that this is going to be resolved by the provision of humanitarian relief or humanitarian protection. It is because additional human rights monitoring and protection, if deployed, could provide us with a better situational analysis, strengthen preventive capacities, and demonstrate the international community's focus on and commitment to protecting Palestinian civilians under an increasingly brutal Israeli occupation. In respect to that, addressing the shrinking space of civil society organizations and human rights defenders is a priority, and the continued provision of humanitarian and legal assistance in collaboration with Palestinian and Israeli civil society is a vital component of humanitarian action. Second, the Special Rapporteur's report refocus us on an inalienable truth. As a peremptory norm of international law, the right to self-determination cannot be derogated from under any circumstances, and it gives rise to obligations, erga omnes, obligations owed to the international community as a whole. Our humanitarian diplomacy, targeting third parties, third states, third international organizations, should move along the axis of state responsibility for internationally wrongful behavior, beginning with Israel's obligation to comply and that of third states to not recognize, aid, or assist its wrongful behavior, shall it persist. We are also positioned to bring attention to the obligation of third parties to cooperate in bringing breaches and serious violations to an end by all lawful, and they are plentiful, means available to states and to the United Nations, and by holding third states accountable should they be derelict in this, their duty. It follows from the fact that the duty to cooperate concerns the international community writ large, that we develop a network of secondary obligations. We've established a network of secondary obligations. What this means is that the beneficiary of the duty imposed on third states to react to a violation is not only the victim of the first violations, Palestinian tormented by Israel, but also the international community as a whole. In the case of a violation of a peremptory norm, such as the right to self-determination, the legal character of the secondary obligation to cooperate is the same as that of the primary obligation, meaning that the secondary obligation to cooperate in bringing Israeli wrongful behavior, that's prolongation of occupation, to an end, possesses a peremptory character and therefore prevails over political preferences, prevails over political convenience, or indeed over other state interests, which all too often carry the day. Third, and finally, the report argues that the Middle East peace process and subsequent bilateral peacemaking attempts have proven ineffective for the reason that they have not focused their approaches on human rights, particularly the right to self-determination of peoples, of the Palestinian people. They've overlooked the settler colonial underpinnings of Israeli occupation. What we should do is openly confront the attempted permanency of Israeli occupation, including the actions undertaken by it to acquire Palestinian territory in perpetuity and settle it with its own nationals to the absolute detriment of Palestinians. one advice that we have seen special rapporteurs make, and more recently the Human Rights Council Commission of Inquiry, is to address this question to the International Court of Justice, the ICJ. I think given changes in both factual circumstances and the development of international law in the areas of use cogence and state responsibility since its last advisory opinion in 2004, perhaps it's time for the court to revisit that opinion and correct some of the errors, the legal errors made then, if it is requested to advise on the legal consequences of the continued refusal by Israel to end its occupation, and on the obligations of third states and the United Nations to ensure that Israel respects international law. All of this not subject to negotiations. Those of you familiar with the 2004 advisory opinion, I suspect this is most on this call, would know that while there is a recognition of Palestinian self-determination, that is subjected to the successful outcome of bilateral negotiations. I think what the report does is it clearly states that the right to self-determination is inalienable, non-derogable as a peremptory norm. It cannot be subjected to the outcome of negotiations, or indeed to the resumption of negotiations. So as global civil society, we should put our resources behind an ICJ advisory opinion. We can and should commit resources to preparatory work and the necessary mobilization that would have the UN General Assembly ask the ICJ for an advisory opinion on the refusal on the part of Israel to respect the right of Palestinian people to self-determination. Thank you.